If you were hurt in a slip and fall accident, there's a good chance that someone's already told you that you should have been looking where you were going. I want to give you a more honest picture. You may feel like what happened was a moment of clumsiness, but that's often not the case. Property owners and businesses in Alabama have a legal duty to maintain safe conditions for the people that visit their property. When they fail to maintain that duty and someone gets hurt, that's a legitimate legal claim. I am Asthana at Caldwell, Wenzel, and Asthana Personal Injury Lawyers. We represent injured clients in Florida, Alabama, and Mississippi, and I would like to talk you through what this means for you. Slip and fall cases fall under premises liability law, which covers a wide range of situations. Wet or slippery floors with no warning signs, uneven pavements, cracked sidewalks, or broken flooring, poorly lit stairwells and parking lots, loose or damaged carpeting, missing or broken handrails, objects left in walkways, or outdoor hazards like unmarked drop-offs or poorly maintained steps. These accidents, they happen everywhere. Grocery stores, restaurants, apartment complexes, shopping centers, office buildings, or hotels. If you fell somewhere and something about that property was not the way it should have been, you should contact a lawyer and get a free consultation. If you were hurt in a slip and fall, a few things need to happen right away. Report the incident to the property owner or manager before you leave. Ask for a written incident report and keep a copy. This part is extremely important. Photograph the hazard that caused your fall. The wet floor, the broken step, or the missing signage. Make sure to take a photograph of what caused your fall before you leave, or come back same day if possible to take it. You want to do this before the hazard is cleaned up or repaired. Also, get contact information from any witnesses. Then, make sure to get medical attention even if your injuries feel minor at first. Soft tissue injuries, fractures, or concussions can worsen quickly. That medical record, tied to the date of your fall, is essential for your claim. Contact a lawyer as soon as you can. Surveillance footage is one of the most vital pieces of evidence in these cases, and many businesses overwrite their recordings within days. We can send a preservation letter immediately and stop that from happening. Most slip and fall cases come down to this one key question. Did the property owner or the business know about the hazard, or should they have known about the hazard? Spills left unattended for too long. Floors that were falling apart for weeks before anyone fixed it. Lighting that had been reported as inadequate. Stairs that were non-compliant and failed inspection but were not repaired. In many cases, the dangerous condition existed long enough that the owner had a clear obligation to address it but failed to do so. Slip and fall accidents cause a wider range of injuries than people expect. Broken wrists or arms from bracing a fall. Hip fractures that are among the most serious outcomes, with nearly 320,000 older adults that are hospitalized for hip fractures resulting from falls. Traumatic brain injuries from striking the ground or a hard surface. Spinal injuries, and soft tissue injuries that don't really show up until days after the accident. After a fall, don't assume that your injuries are not significant enough to pursue a case. Get medically evaluated and let your medical records tell that story. A few things that hurt these cases: failure to get medical care or delay. A gap between your fall and your treatment lets the other side argue that your injuries were a result of something else or that you were not that hurt. Failing to photograph the scene immediately. In some cases, a failure to get a photograph of what caused your fall may gut your case entirely. Property owners tend to fix hazards quickly after an incident, sometimes within hours. Giving a recorded statement to the property's insurance company before speaking to an attorney. Adjusters in premise liability cases are experienced in finding language that shifts the blame onto the person that fell. Accepting a quick settlement offer in your case before you've had a chance to fully get evaluated medically and have an idea about your injuries. And lastly, do not post about your injuries or your fall or anything related to that on social media. The standard defense used against you in a slip and fall case is that the hazard was open and obvious and you should have seen it. Insurers also argue that you weren't watching where you were going or that your injuries were pre-existing. These types of arguments are used aggressively, especially in Alabama, where finding of even 1% of fault on your part can bar your recovery financially completely. This legal rule in Alabama is called contributory negligence. Florida and Mississippi follow a different standard called comparative fault, which means that your recovery is reduced by the percentage of fault rather than being barred completely. But in all three states, insurance companies will push your share of fault as high as possible, which is why how a slip and fall claim is built and documented from day one matters. Under Alabama premises liability law, the duty of care that is owed to you depends on your status as a visitor. If you're a customer or a business invitee whose presence benefits the property owner, they owe you the highest level of care and must actively inspect for and address hazards. That is the standard that applies to most of the slip and fall cases that we handle. Alabama's contributory negligence rule also applies here. At Caldwell, Wenzel, and Asthana, we moved very quickly at the start of slip and fall cases because the evidence window closes fast. We send preservation letters to protect surveillance footage, maintenance logs, and inspection records before they disappear. We investigate the property, document the hazards, and build a liability cause using the owner or the business's own records. We work with your medical providers to document every injury thoroughly, and we're ready to take these cases to trial if the property owner or business refuses to take responsibility. If you were seriously hurt in a slip and fall accident in Alabama, Florida, or Mississippi, don't let anyone tell you that your case is not worth pursuing before you've had a chance to look at all of the facts. Call Caldwell, Wenzel, and Asthana for a free case evaluation. There is no fee unless we recover, and we look forward to working for you.